Hello, my name is Doreen Hartwell, and I'm a lawyer in Las Vegas, Nevada. Stephen?
Good afternoon. I'm Erin Lageson, and I am the presiding judge of Department 3 of the Oregon Court of Appeals, so just to the south of your state.
My name is Steve Jewett. I'm a county court judge in the Ninth Judicial Circuit of Florida, which is Orlando, Orange County. And I am like about 3,000 miles from your state in Florida. So good afternoon.
And you may introduce yourselves.
Good afternoon, judges. I'm Caroline Quevedo. My favorite Supreme Court justice is Sandra Day O'Connor because she overcame adversity and paved the way as the first female Supreme Court justice, and because she's from my hometown of El Paso, Texas.
Hello, my name is Marie Vandenbosch, and my favorite Supreme Court justice is Earl Warren for his outstanding leadership in unifying the court to advance the social progress of our nation.
Hello, my name is Cami Fairbanks, and my favorite Supreme Court justice is Louis Brandeis for being the people's lawyer and for his views on the fundamental right to privacy.
Hello, I'm Bailey McAllister, and my favorite Supreme Court justice is Ruth Bader Ginsburg for her grit and fight against gender discrimination. On behalf of the Tahoma School District, our advisor Gretchen Wolfing, Unit 5, and the state of Washington, we thank you for judging us today.
Great. So the question this afternoon is going to be question 1. A result of the decision in Wisconsin versus Yoder is that, quote, any parent/guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious beliefs, end quote. Do you agree or disagree with this result in the decision? Why or why not? And what words, if any, are found in the U.S. Constitution or in state constitutions that protect the right to an education? And lastly, how have courts balanced religious beliefs with other rights? You may begin.
Spiritual freedom is the root of political liberty. As the union between spiritual freedom and political liberty seems nearly inseparable, it is our duty to defend both. Thomas Paine.
We agree with the result of the decision in Wisconsin v. Yoder 1972, in which the court unanimously held that the state could not require children to attend school past 8th grade.
Yoder applied the free exercise test established in Sherbert v. Vanner, 1963, requiring laws that unduly burden the First Amendment right of free exercise of religion to be narrowly tailored to fulfill a compelling state interest. The court determined that the state interest of education was not compelling enough to take precedent over the Amish parents' free exercise of religion, which was burdened by the conflicting education taught in secondary school.
Yoder also addressed the right of parents to direct the upbringing of their children, which was first recognized in Meyer v. Nebraska in 1923 and later described in Troxel v. Granville 2000 as one of the oldest fundamental liberty interests recognized by the court. The decision in Yoder protected the ability of parents to exercise this liberty interest without unreasonable government interference.
Yoder set a precedent for religious and educational freedom that has impacted numerous cases. For instance, in Runyon v. McCrary, 1976, the court cited Yoder's opposition to compulsory public school attendance to strike down racially discriminatory policies that barred African American children from attending private school.
Through the application of judicial precedents, Yoder upheld the free exercise of religion and expanded liberty in the realm of education.
The United States Constitution does not address the right to education, granting states the authority to regulate the extent to which this right is retained.
In San Antonio Independent School District v. Rodriguez, 1973, the court affirmed that the right to education is neither explicitly nor implicitly found in the United States Constitution. When left to the state constitutions, the degree of protection afforded to the right to education varies from state to state, with only 22 states recognizing education as a constitutional right.
Among the strongest language in the country protecting the right to education, Article 9, Section 1 of the Washington State Constitution was applied in McCleary v. Washington, 2012. The Washington State Supreme Court ruled that the state was failing to meet its constitutional duty to make ample provision for the education of all children residing within its borders, resulting in an increased state budget for public education.
Meanwhile, the general and uniform language in Minnesota's Education Clause was not strong enough to persuade the Minnesota Supreme Court to further the right to education by requiring the state to fully provide equal per pupil funding in Skeen v. State, 1993.
In the absence of a federal standard, the right to education is left to the state constitutions, each differing in the magnitude of protection reserved for this right.
Courts have balanced religious beliefs with other rights by establishing tests and procedures to weigh the free exercise of religion with the preservation of conflicting rights.
The court balanced religious liberty with the equal application of the law in Reynolds v. United States 1879, when it upheld the prosecution of an individual who practiced bigamy on religious grounds. Reynolds affirmed that religiously motivated actions are not protected by the Free Exercise Clause when they come into conflict with the law.
Moreover, in Employment Division v. Smith, 1990, the court expanded on the Sherbert test used in Wisconsin v. Yoder by ruling that religious individuals must abide by neutral state laws of general applicability. This procedure has been used to weigh public safety with the free exercise of religion during the COVID-19 pandemic.
In February, the court ruled in South Bay United Pentecostal Church v. Newsom that California may limit capacity to 25% and place restrictions on singing and chanting, as these laws are neutral and generally applicable.
When freedom of religion conflicts with other rights and state interests, the court must rely on past precedents and set forth new standards in order to strike a balance between contrasting values.
Thank you. So in the area of constitutional law, what does separation of church and state mean?
In the state of Washington, the separation of church and state is addressed in Article 1, Section 11 of the Washington State Constitution, and this section was applied in the Supreme Court case Locke v. Davie when the Supreme Court upheld a Washington statute that prohibited the use of state funds for sectarian schools.
Another aspect of the separation of church and state is the fact that states and the federal government cannot require mandatory oaths of loyalty to particular religions. This can be seen throughout a regular school day, which goes on without any sorts of Bible readings or prayers as a result of the landmark case, School Districts of Abington Township v. Shemp, as well as the other landmark court case, West Virginia State Board of Education v. Barnett.
Most notably, the First Amendment addresses the separation of church and state through the Establishment Clause and the Free Exercise Clause. As seen in Torcaso v. Watkins, the state cannot require people to take oaths of loyalty with a certain religion, meaning that religious beliefs and state interests have to remain separate from one another.
Well, you guys are all from Washington, and your constitution in the state of Washington has the separation, and so does obviously the United States Constitution. Should there be a right to education in the Constitution? Should that be nationally recognized as a right?
I would argue that education does not need to be recognized as a right on the federal level, but instead the U.S. Department of Education should increase its funding in order to create a more level playing field among the states, because currently the U.S. Department of Education only funds around 8% of the funding that actually supplies public education throughout the states. And so rather than it being enumerated in the federal Constitution, I would just argue for an increase in funding.
To expand on my colleague Bailey's point, I also agree that the federal government should increase funding for education. President Biden recently proposed an education plan that would increase funding in order to address issues with low-income school districts, K through 12 school districts, as well as provide funding for free community college. And I believe that parts of Biden's plan should be implemented in order to address low-income issues in education all across the country.
I disagree with my colleagues. I do not believe that the right to education should be enumerated in the United States Constitution. The court has been very clear about this. In San Antonio Independent School District v. Rodriguez, the court found that the right to education is not implicitly nor explicitly found in the United States Constitution. Additionally, with the 10th Amendment, states are allowed to take education on as their own responsibility.
Well, but the 10th Amendment says that just whatever's not put in so if it was, then it wouldn't be in the 10th Amendment, correct? It would, if it became a right in the U.S. Constitution. Okay.
Yes, so you are correct.
Take everyone's time.
regarding the 10th Amendment, but I believe that it's, to agree with my colleague Cami, it's important that education was not enumerated as a federal right, because instead negative rights, like those enumerated in the Bill of Rights, such as the right to freedom of speech, should be prioritized over positive rights, as positive rights expand federal power and leave more room for the abuse of government power.
How should a student's right to education be weighed against a parent's religious belief?
So this is something that Justice Douglas dealt with in his partial dissent in the Yoder case. Justice Douglas argued that the constitutional means of the children were not weighed properly, and instead the court had only evaluated the parent's free exercise of religion, not the child's. I do believe that the court should place a heavier balance on the children's free exercise of religion, and historically the court has found that children do have constitutionally protectable interests, such as the freedom of speech within schools. Additionally, the court has also found that children are competent enough to make certain decisions. And Bellotti v. Baird, the court found that children do have a right to address their maturity within court and prove to the court that they do have the capacity to make their own decisions with regard to religion.
Additionally, the United States is the only United Nations member state that has not ratified the UN Convention on the Rights of the Child. And I would argue that the United States really needs to ratify this convention in order to follow what Justice Douglas said in his partial dissent, in order to give children more of a say in relation to their parents, because currently parents almost have the ultimate say until the child reaches the age of majority at 18. And especially Article 12 of the UN Convention on the Rights of the Child, this would really help to reassess children's rights in all of these Supreme Court cases.
In your prepared remarks, you discussed the changing standards for evaluating whether a neutral law burdens the exercise of religion in a way that violates the free exercise clause. Which of those standards, or if not those standards, what standard would you think is appropriate to implement the rights of the free exercise clause?
Religion is viewed as a suspect classification, so I agree with the Supreme Court's standard for religion, in which strict scrutiny is used to evaluate cases of religious freedom. This requires that laws that burden the exercise of religion must serve a compelling state interest and be narrowly tailored to fulfill this interest. And I believe that I would argue that this is a good way to weigh the free exercise of religion with government interests.
The way that the court has interacted with religion over the past year during the pandemic has greatly changed from their interpretation in Employment Division v. Smith. Employment Division v. Smith stated that all religions must abide by neutral state laws of general applicability. However, in places such as California, this is being seen as any challenge to religion. The court has taken this to see any challenge to religion is a bad thing. Governor Newsom has placed restrictions on California's ability to meet in capacity, such as the restriction to limit capacity to 25%. And many churches objected to this because it was a restriction on their right to meet.
Stephen, you're muted.
But I mean, what's the rationale for that? Is it the common good or the safety weighed against the ability for them to meet?
So in California specifically, that law was, or that guideline was put into place against all meetings, not just church meetings. And that law was put into place to specifically guide the common good as opposed to individual rights. This law was based on the mentality that if we all band together and limit capacity to a certain extent, we'll be able to get through this pandemic a lot faster.
Okay.
Time.
All righty, great job.
I'll start. Great job. I thought your prepared remarks were well done. And I liked your theme, which you set out at the beginning with the Thomas Paine quote, spiritual freedom is the root of political liberty. And you supported that throughout your your prepared remarks and in your responses to our questions. You had tons of Supreme Court precedents, and it was refreshing. You made some arguments and took an approach that was a little different from some of the other teams. So it was nice to hear something a little new and different this afternoon. You incorporated, in response to the question asked, in your prepared remarks, you incorporated references to various state constitutions and how it related to the right to education. I thought that your responses to our questions were responsive, and you always were able to pull in an example, and you used historical examples and current events. And I thought that was very good. Well done. All of you were very responsive and great participation, and just a good job.
Yeah, I liked it, enjoyed it a lot. It was interesting how you used a lot of different sources. In other words, it wasn't just the law. I mean, you brought in the U.S. Department of Education and the funding issue, which is not something a lot of people talk about, but of course would be a major portion in discussion of anything that we're dealing with in this issue. If it becomes it does become a right that's enumerated, then the cost of that is going to be significant, and I think that was a good thing to put in there. And of course, it's interesting that you agree with Yoder, but you also cite a lot to the Douglas dissent, which in essence said, hey, yeah, I get it, but we have to look at the fact that not everyone's going to go to be a farmer, picking turnips for the rest of their life, and so we shouldn't do this. So I thought that, but it's not, you weren't inconsistent. In other words, you explained that, but you still used that in an answer for another one. So I think that was well done. Good job.
I, of course, echo everything that my co-judges have said. I especially appreciated that you included knowledge or references to your state constitution, not only in your prepared remarks, but in response to the follow-up questions. You addressed the church and state question by a very specific reference to the law under your state constitution. And your state in particular, at least right now, has been doing some very interesting things with its constitution, and particularly in protecting the rights of youth or children, as it looks like you're aware. And so the fact that you were able to employ that knowledge in response to this question, I think it shows a broader range of knowledge than we sometimes see. The other thing I really liked about your responses, we're discussing about what the United States should do in terms of adopting the rights of children. And the United States has not necessarily addressed the rights of children, as you explained very well. In the case law, it's been focused a lot on parental rights. And so I found it really interesting to hear your thoughts on that. And frankly, I think there's a lot of work to be done in that area, and I'm very, very glad that to hear from such bright people who I hope will keep that in mind as you start to participate more and more in our democracy. Great job.
Yeah, to echo what Aaron said, I think what I did find interesting was that Washington has been sort of on the tip and the forefront, tip of the spear of the rights of children and whatnot. But yet you guys were more than willing to just go with Yoder and give it up. So it's an interesting dichotomy, and but I really enjoyed it. Very good job.
Yes, well done, and good luck, guys.
Thank you so much, judges.
Thank you.
Thank you for what you do, Teach. Very important. I appreciate you. Both
Thank
of you.
you. It's my honor.